Foster Care Committee. Today, we are going to have a hearing on 2132, House Bill 2132. And let me just set the stage for this hearing. So we are going to be hearing testimony from proponents and opponents today. There's no neutrals that I know of. We are hearing a bill that will redefine neglect, and it's going to be up to us committee members to decide the best path forward for Kansas. This could have a very significant effect on our system. So let's listen up, let's ask lots of questions. We are going to hear all of the proponent testimony first, and then we will ask questions. So write down your question and who the conferee is that you would like to answer. Then we'll do the same for opponent. We'll hear opponent testimony, and then we'll take questions for them. So be sure to keep your list going. I am going to limit it to one question at first. So one question at a time, and then if there's time remaining, we will take seconds, okay? And maybe thirds if there's time. Conferees, I would ask you to keep it to 3 to 4 minutes. If you can do that, I think that's reasonable for our time. We are going to start today with research. Natalie Nelson, you would go to the podium. Thank you.
All right, good afternoon, Chair Howerton and committee members. I'm Natalie Nelson with Legislative Research. The chair asked me to go over a 50-state survey that my colleague Julia Kofoid actually put together last November in our office, and it pertains to state definitions of neglect. And I also want to note, before I get too far in, that there's a publication by Casey Family Programs in your materials today that provides a more in-depth analysis of the various statutes. Sort of the purpose of our KLRD's memo is to provide you the actual language of the neglect statutes for your review, which is why it's so lengthy. So, and I am not going to read each definition, but I will give you some brief highlights on what we found. Just as a starting point, we started out in this document providing the federal definition of child abuse and neglect, which is found in the Child Abuse Prevention and Treatment Act, which is at a minimum any recent act or failure to act on the part of a parent or caretaker which results in death, serious physical or emotional harm, sexual abuse or exploitation, or an act or failure to act which presents an imminent risk of serious harm. So in the memo, we tried to make note of variations from the federal definition, and it's relevant to note here that no state uses that definition verbatim, but there are pieces here and there, weaved throughout the different statutes. So we also looked at whether states had reviewed their definitions of neglect in the previous 5 years, in the last 5 years, and 39 out of 50 states, plus the District of Columbia, had at least introduced legislation amending the statute where the neglect definition can be found. However, I would point out a caveat to that is that we didn't really go much deeper into the specifics of what was changed, so it may be a little bit of an inflated number based on how statutes are organized. So there may be a ton of things in that statute. So we just looked at to see if that particular statute had been amended in the last 5 years where the neglect definition is found. But I can definitely follow up on anything that, if you are interested in whether some of those states have made recent changes. So highlights on that survey, I would mention that about 20 states have language indicating an exception to neglect for poverty or financial inability to provide necessities. So with the most common phrasing to be something like, does not provide XYZ necessity when financially able to do so, or offered financial or other reasonable means to do so. So, and then with respect to providing necessities of care, states use differing language such as failure or refusal, and that can be found in 6 states, at least 6 states: Arkansas, Colorado, New Mexico, South Dakota, Utah, and Wyoming. The District of Columbia uses the term refuses or is unable to provide those necessities. Louisiana is a little bit different in that they say, their statute says neglect is inability, refusal, or neglect with respect to necessities, but they use failed, refused, or unable with respect to seeking financial or other reasonable means. And then speaking of reasonable, Louisiana uses refusal or unreasonable failure. Mississippi and Nevada uses the term neglect or refuses when able to do so. Tennessee and Virginia uses the phrasing neglects or refuses. And then West Virginia and Wisconsin uses the term refusal, failure, or inability to provide those necessities. And that, the rest of the statute is also varying in those different states, but I just sort of, distilled it down to those action words, I guess. And then the last two things I would mention is that there are, 8 states that use either like serious harm or serious offense, serious neglect, something using the term serious in their neglect statute, which would, parrot that language found in the federal definition. And then there are 3, there's New Jersey, New York, and the District of Columbia use the phrase imminent danger or imminent harm, so which is also found in that federal definition. So that is all I wanted to highlight for you today, considering how many different people we have here to testify. So if anyone has any questions for me, I will be happy to take them.
Okay, thank you very much, Natalie. Are there any quick questions concerning what she just talked about? Okay, thank you, Natalie. Jesse, if you can go over the bill for us, thank you.
Thank you, Madam Chair. Good afternoon, committee. Jesse, Assistant Revisor with the Revisor of Statutes Office. I'm going to take the next few moments to go over what is exactly in House Bill 2132 as introduced. So this bill amends 3 different statutes, the first one being the current statutory definition of neglect. And so as far as the changes being made to that definition, neglect currently means acts or omissions by a parent, guardian, or person responsible for the care of a child resulting in harm to a child or presenting a likelihood of harm. The bill before you today sees a striking of that phrase, presenting a likelihood of harm, and leaving the definition to be limited only to neglect, to acts or omissions only resulting in harm, taking out that likelihood aspect. Further, the current definition states that such acts and omissions shall not be due solely to the lack of financial means of the child's parents or custodians. This bill, as introduced, keeps that language in there and then goes further to include that the inability to provide for a child by a parent, guardian, or person responsible due to inadequate financial resources thereof shall not be considered neglect for that reason alone. The current definition of neglect goes into 3 different examples of what neglect could mean, which under current statutory definition includes failure to provide the child with food, clothing, or shelter necessary, failure to provide adequate supervision that could result in bodily injury or likelihood of harm, and then third, a failure to use resources available to treat a diagnosed medical condition if that treatment helps the child. So this bill, as you see before you, amends all 3 of those examples from failure to do an action to refusal to do that action. So when failure to provide adequate supervision, failure to use, the definition in the bill before you says refusal to do those things shall count as neglect. So that changes all 3 of them. But in that first example, in paragraph Z1, it would limit the parent, guardian, or person responsible for the child's refusal to when the parent or guardian or person responsible for the child is otherwise financially able to provide such care or offered financial or other reasonable resources to provide such care. So that's limiting in the aspect of refusal to provide those necessary food, shelter, when that person is otherwise financially able to do so, or they are offered resources to provide that care. In the second example, under the definition, which would be Z2, the bill as introduced removes that likelihood of harm aspect. So this example relates to the adequate supervision being provided. So this bill would change that to a refusal to provide adequate supervision that would result in bodily harm. Current definition has resulting in a likelihood of harm and harm. This bill would take out that likelihood of harm aspect, just as in the lead-in language. So those are the changes in the bill before you to the definition of neglect. The second section amends KSA 382234. This is a statute that governs the contents of a petition filed with the court when a child is being requested to be removed from the home. So currently, under statute, Section A7 requires that the petition specify facts that demonstrate that allowing a child to remain in the home would not be in the best interest of that child, and that child would sustain harm if they were not removed. The bill before you today determines that so the current statutory language says harm right there. So the bill amends that to say imminent harm. So then that standard would change to otherwise sustain imminent harm if not removed. It would also goes to add new language that would require certain facts shown in the petition. They require those facts to have a causal relationship between the conditions in the home and the imminent harm that would be alleged. And to show those facts, the petition prohibits that certain facts in that list below may not demonstrate imminent harm if they are asserted alone. So for example, in that petition, you cannot assert that there is imminent harm to the child due solely to community or family poverty, or due solely to disability or special needs of a parent or child. So within that list of items, none of those items can be alleged in the petition to be harmed by themselves. In addition to these facts, the petition would also require that such harm outweighs the harm to the child as a result of the requested removal. The last section amended by House Bill 2132 amends KSA 382243, and this statute governs the court's entry of temporary custody orders. So when a court has determined there's probable cause that would require an entry of a temporary custody order, this bill before you would require that the court further consider some things, such as participation of parents, guardians, or the person responsible for the child, and whether their participation in prevention services would prevent or eliminate the need to remove the child. So before the court enters that temporary custody order, the court must consider if that participation, the parent's participation, would allow the court to place that child back with the family. So that's a consideration before the entry of the order. So if the court determines that such participation could prevent or eliminate the removal, then the court shall ask the parents if they'd like to participate, and the parents have the right to confer with legal counsel about agreeing to any proposed services as a condition of having that child returned or to remain in that care. After that consideration and the parent has agreed to prevention services, the court shall place the child with such parent and eliminating any requirement or need for that temporary custody order. So all these things are required of the court to do before entering that temporary custody order. And then additionally, before using a temporary custody order, the bill also contemplates that the court would be required to consider whether an issuance of a temporary order of protection directing the removal of a person or person from the child's residence would prevent a need for removal. So that's a consideration that would be required before the order of temporary custody. And these protection orders are already authorized under the statute that is being amended in this section. And if enacted, the bill would take effect on publication in the statute book.
Okay, thank you. Are there questions concerning the revisor and the bill? Representative Humphries.
Thank you, Jesse, so much for that. So in the changes in the definition, when it says, used to say failure to do, and now you're going to say refusal. But does refusal necessarily mean that the parent has to have knowledge of what they're supposed to do?
Unfortunately, I think that would be up to the courts to decide whether there was a prerequisite of knowing that this type of care was supposed to be provided in order for that person's actions to be construed as a refusal.
So is there a place here, which, and I mean, I could have very well missed it when you were explaining everything, that somebody who they don't, it doesn't fall under neglect because they're not refusing to do something, they're just not doing it because they don't know they're supposed to be doing it. So, you know, in the case of either, I mean, I don't, you know, whatever the situation is, they don't know they're supposed to be doing that. They're not refusing to do it, they just don't know. So they're failing to do it. And the child is being harmed or will be harmed.
Yeah.
Where does that fall within all of this?
So I do not think that would fall under the proposed definition of neglect, since this bill is removing the word failure, that person, whether or not they know to do these things, that failure is no longer under this definition to be neglect.
Okay. Thank you. Thank you, Madam Chair.
Okay, Representative Burkamp.
Thank you, Madam Chair. So under the list of things that they cannot consider, page 8, so if a parent is, I guess, currently using drugs or on substance abuse, that's a factor that you cannot take into account for the welfare of the child. Is that correct?
That fact could not be used by itself to demonstrate that the child is in imminent harm in the petition.
Okay, so a little bit maybe follow up with Representative Humphries. I guess in my mind, if a parent is in that state of mind, I could easily see how, again, yeah, they're not refusing, they just don't have the mental capacity to do so. And I'd just be a little bit concerned over the verbiage that we'd have some issues on that front. Thank you.
Representative Carr.
Thank you, Madam Chair. As sort of a piggyback on my previous colleague's question, individually, that would not be a disqualifying factor, but added with another one of those factors. So if in fact that the individual is suffering from substance abuse as well as being impoverished, now we're not talking about an individual item, there's multiple. How does that work?
Yes, so those two facts together from this list could be put on the petition to demonstrate that the child is in imminent harm.
So that's to say that if the individual was disabled as well as impoverished, that those would be two, as combined together, those would be disqualifying factors?
So those are two things that a person can put in the petition requesting the removal. So whether or not that child is actually removed or those facts demonstrate a capacity to take care for the child, they would be together in that petition allowed to show that there is imminent harm to the child.
Thank you very much, and thank you, Madam Chair.
Representative Neighbor, and some of these questions may be answered in testimony, so, but go ahead.
Actually, that was partially answered, and I'll ask during testimony.
Okay, thank you. And then Representative Riley?
Yeah, thank you, Madam Chair. I've had a couple cases that were strange to me that social worker came in and reported, and then the children were reported to the court. In one case, where the social worker came in and reported that twice the refrigerator was empty, and so therefore that was neglect. Where does that fall? Then I have one more question on that. Okay, while you're thinking about that, then here's the other case. Different situation, but the social worker came in, was checking things out, and noticed that there weren't a fire extinguisher in the kitchen, and so therefore reported the children as being in harm. Some things seems a little extreme of where we're going. So are we sorting that out with this new definition?
If you want to wait on that, maybe Deputy Secretary Keys could kind of weigh in on that.
Sure. What I can say is, in those instances, I won't opine whether those actions or omissions were neglect, but those were likely alleged under those three examples of refusal to provide or failure in the current statutory definition, failure to provide food, clothing, or shelter necessary to sustain life or health, or the failure to provide adequate supervision. So that is the current statutory requirement. So that language is currently used to state that items like that may be considered neglect.
Okay, committee, we're going to move on. Thank you very much. Very thorough explanation. We're going to move on to proponent testimony. First up is Nick Reinecker. You could state your name and if you represent someone, welcome to committee.
Thank you, Madam Chair and committee members for allowing me to speak today. My name is Nick Reinecker, private citizen from Inman, Kansas, and I support this bill. Ensuring the safety and welfare of a child is paramount to protecting the life of all children. Your oath to defend the Constitution, so help you God, is your framework in how to proceed. Allegations of innocent until proven guilty individuals should be based on probable cause of a crime and afforded proper due process. Gatekeepers and peace officers have individualized discretion, which may hinder these allegations if not based on criminal allegations pursuant to the Constitution. One person's definition of failure or likelihood to cause harm versus another may be different, so it is important to err on the side of liberty. And when refusal comes in, then by all means, remove that child and throw the book at them. Otherwise, one could argue all families need to be monitored for potential likelihood of harm to self or others because of our human condition. Think about it. Some people think letting a child play outside or in the mud or on a swing is likely to cause harm or has significant danger or risk, or allowing kids to be on a screen for hours a day, or eating the latest sugar cereal, or drinking the new cool energy drink. And let's not even get into the whole vaccine thing. Again, back to that individual discretion. Err on the side of liberty, because unfortunately statistics show disparities in some of these areas, and we have seen serious and fatal cases, children, fall through the cracks while disparate abuses using a controlled substance status of what is now legal in a lot of states to historically justify removal. I remember a time when if you mentioned the M word, SRS would be at your door and the police would be in hot surveillance. Damage done. This has subsided some, and I will acknowledge that some district attorneys are not charging certain possession crimes. I don't like that either, because if we have a crime, there should be swift and certain punishments by the government sword, like a 30-day minimum mandatory sentence for possession of methamphetamine, or 90 days minimum mandatory sentence for violent, threatening, or forceful behavior like battery. Why is domestic battery a Class B crime, just like cannabis possession? Also, treatment does not equal safety. Yes, it can create temporary behavior change, but until a heart is changed, it is just that, temporary. Now, I would think before a child starves to actual death, there would be judge-approved articulable physical evidence of malnutrition that would show, along with a general state of fear that would be present, which could be used as evidence. And just because you have years of case law doesn't make it historically constitutional, as it was meant to be at our constitutional republic's founding. I would like to turn your attention to the testimony from our peace officers associations. After number 1, it says, there will be no provisions for removing a child from a harmful situation if they are found prior to harm actually occurring. Well, if they're in a harmful situation, then charge them with a crime. And then down there, we struggle to understand leaving a child in a potentially harmful environment. Whose home is not potentially harmful? I go on and on. Please pass this bill. There are so many other things that I could say, but time is of the essence, so I thank you for allowing me to speak today, and I'll stand for any questions.
Thank you very much. Next up is Gail Kozad with Kansas Children's Service League. Welcome to committee, Gail.
Am I on? Okay, good. Good afternoon, Chair Howerton, Vice Chair Johnson, Ranking Minority Member Owsley, and members of the committee. I am Gail Kozad, CEO for Kansas Children's Service League. One thing I want to note is that Kansas Children's Service League does serve as the state chapter for Prevent Child Abuse America. Working in the field for almost 30 years, that is really hard for me to believe, I recognize abuse can occur in every socioeconomic status, but unfortunately, nationally, nearly 85% of families investigated by Child Protective Services live below 200% of the federal poverty line. And just for reference, 200% of poverty line for a family of 3 is just under $43,000 or just under $44,000 a year. Families who have means to address issues do so quietly and privately, or they are able to hide within the shadows more effectively. I also know that while poverty can be a contributing factor to future child abuse, it is not the only factor. Most parents want to be better for their child, and when they are provided with support to meet their basic needs and have the opportunity to increase their knowledge and skills around nurturing and supportive parenting, they take advantage of this. Poverty can be an overwhelming place, and often parents do not know where to turn to gain access to the support that they need. House Bill 2132 will further emphasize the importance of supporting families and providing prevention services before a child is removed from their home. Further, Kansas has worked over the past 6 years to increase programs that support families safely in their own home, and this has proven to be very effective, as you have heard from the Department for Children and Families, and the number of children in foster care continues to decrease. These funds already are invested in the state. They are currently, but I will let you know that there currently remains capacity to continue to serve families with funding that is already invested in this state. KCSL is one of those partners in prevention, and I want to note that the state and local communities also invest resources which impact families. And these are resources which DCF can refer families to, and sometimes that is what a family needs the most, a starting point. Foster care should always be a last resort for children. It can be disruptive to their development and just should not be used unless absolutely necessary. KCSL believes the change in definition of neglect will provide an improvement for the child welfare system. Thank you for allowing me to speak in support of House Bill 2132. And of course, at the end, I will stand for any questions.
Thank you very much, Gail. Next is Brenna Viskowski. I should get with people before and find out how to pronounce their names. I apologize if I butchered it.
Thank you, Representative Howerton. It's Brenna Viskowski. You were so close. I appreciate the effort. Okay. Thank you, Chairwoman Howerton and members of the committee for the opportunity to provide this proponent testimony on House Bill 2132. My name is Brenna Viskowski, and I'm with Kansas Appleseed, a nonprofit with a long history of unwavering commitment to advocating for the rights and well-being of children. Despite some improvements to the foster care system in recent years, it remains a system in crisis that is not always serving in the best interests of the children in its care. House Bill 2132 would be a significant step in bettering the system, preventing unnecessary trauma to families and children due to the removal of those children from their homes. Instead, focus can shift to supporting families in need to help them provide for their children, strengthening positive outcomes for all in the family unit, and reducing unnecessary strain on the foster care system. This is especially important when we consider the impacts of entry into the foster care system on children. Trauma from being removed from their home and kept from family, of course, but also increased risk for depression, anxiety, PTSD, and other mental health issues, as well as higher risks for disruption in their brain development and worse academic outcomes. Additionally, according to the most recent federal review, Kansas foster children continue to experience placement instability with a rate of over 6 moves per 1,000 days in care. Reviewers also found that cases only achieved timely reunification 27% of the time. The Kansas foster care system has close to 6,000 children in care, almost twice the national average, and the largest portion of them are there due to neglect-related reasons. House Bill 2132 recognizes that conflating poverty with neglect ignores the complicated realities of families facing poverty and creates the fundamental distinction that a parent's incapacity to provide for a child is not the same as an unwillingness to do so. Too many hardworking Kansans are still struggling to put food on their tables, gas in their cars, and a roof over their head. They should not have to fear having their family torn apart on top of it all. The changes presented in House Bill 2132 would support those families who are doing their best but just need help, rather than having their children put into the foster care system where others will be compensated to care for them. Family preservation services cost between $5,000 to $10,000 per family per year, while foster care placements can cost up to $136,000 a year per family. That means the state is likely to see more positive outcomes with cost benefits of up to $126,000 per family experiencing poverty that is kept together under this legislation. What seems like a minor language change can keep hundreds of families together in Kansas and improve their future ability to thrive. It would also be the first step in rebuilding trust with the system so those families who are struggling feel safe accessing the supports and resources they need, rather than fearing the removal of their children if they seek help. Passing House Bill 2132 would also protect the most vulnerable children and families in Kansas. People of color and people living in rural areas experience poverty at higher rates. Meanwhile, children of color are also overrepresented in the foster care system. Providing needed family services rather than punishing these vulnerable families facing poverty could help reduce the inequities Black, Indigenous, and rural Kansans face due to their economic conditions. This is good legislation that aims to keep families together, and through this, reduces strain on an already overburdened foster care system. Kansas children deserve to grow up in healthy families, not foster homes, if it can be avoided. We cannot expect the foster care system to serve as the only solution when families do not have the means to completely provide for their children, despite their best efforts. Instead, we can create a more compassionate and effective child welfare system that prioritizes the well-being of children and families. I urge you to support House Bill 2132 in order to make sure the most vulnerable children in Kansas have the best opportunities for successful futures. Thank you, and I can stand for questions at the appropriate time. Also, I apologize if I was going in and out. It sounded like the mic might have been going in and out. No? Great, just me then.
You're good. Thank you very much. Okay, Crystal Hedrick with Children's Alliance of Kansas. Welcome to committee.
Thank you, Madam Chair, members of the committee. I appreciate you allowing me to be here today. My name is Crystal Hedrick. I'm CEO with the Children's Alliance of Kansas. The Alliance is an association of 18 private nonprofit agencies that collectively provide a full array of services for children and families: child abuse prevention, neglect prevention, family pres, foster care, adoption, independent living, parent, youth, and child skill building programs, mental health, and substance abuse treatment. So members of our alliance have been talking for months about this bill since its conceptual introduction in the fall, and we haven't always been in alignment about how we should approach this conversation. But today I'm here representing all members of the alliance who do support this bill. The idea that poverty does not necessarily cause neglect. Poverty creates hardships that are stressful for caregivers and can ultimately impact their ability to meet the needs of their children. If we can address underlying issues of poverty, we can help decrease the likelihood of child abuse and neglect. In preparation for today, I did a quick review of DCF data that's available on the public website. Last fiscal year, there were 655 kids that were removed from their homes with the primary reason being neglect or truancy, which are both referenced in this bill. We're not talking about thousands of kids. We're talking about just over 650. And while we don't know the circumstances of all of those removals, there are some general things that we do know about those kids. Educational neglect and truancy led to 47 of those kids entering foster care. So youth and older teens who come into care due to truancy or educational neglect usually have other issues and challenges in front of them: mental, physical, and behavioral health challenges that contribute to sporadic school attendance. These are the same youth that we hear about in the foster care system that struggle with placement instability, thus missing more days of school, and they simply can't be enrolled in some circumstances because they don't have a consistent address. For parents of young children who struggle with school attendance, poverty-related issues are often a root cause. Transportation, clothing, school fees. I know for my 4 children this year, I paid over $500 in enrollment and technology fees. So I'm fortunate, well, and if you think about $500 is big for a family that, according to Gail's testimony, brings in less than $3,000 a year take-home pay. So I'm fortunate to have a support system that can help with after-school care. In fact, my kids got home about 30 minutes ago, and had it not been for those substitute care, those backup caregivers, we'd be in trouble because Boys and Girls Club has a wait list, and this isn't just this Wednesday, this is every Wednesday. And so then if we didn't have those people, I would have tough decisions to make, right? Leave work early, call in sick, both risking employment or just leaving kids at home. Leaving kids at home, that leads us to the next reason for removal related to neglect, lack of supervision. Almost 300 kids were brought into care for lack of supervision. So lack of supervision can stem from factors like a parent being overwhelmed with issues related to poverty. For example, the example I just provided, having to choose between school, childcare, employment can lead to a parent's mental health challenges, which can then lead to substance abuse issues, which can then lead to physical medical neglect. The snowball effect isn't just a Dave Ramsey debt relief strategy. We're all just a car wreck or a layoff or a medical emergency away from a potential financial crisis. A couple months ago, I was interacting with a young man who has been in the HVAC profession for a handful of years, and he said to me, it's expensive to live in poverty. And I asked him what he meant. Tell me a little bit more about that. And he said, well, I buy a pair of work boots for $75 because that's what I can afford. That's living within my means. But my coworker, who's been doing this for 20 years, buys the $200 work boots. So I've bought 4 pairs of work boots because the toes run out of them. But my coworker is going strong with his $200 work boots. So the passage of HB 2132 would allow us to formally recognize the preventative measures that can reduce risk factors directly related to poverty. We were one of the first states to implement Family First in 2019. In addition to other prevention-focused partnerships such as Thriving Families and Safer Children, we have successfully and safely decreased the number of kids in care by 24%. This bill is a significant piece of policy that will continue to reinforce the importance of kids remaining in their families with people that they know and love and in their communities. That being said, we must continue allocating resources across the entire state to ensure that communities, courts, law enforcement, DCF, and other prevention providers are able to identify tangible goods and services to families impacted by poverty. Foster care is a last-ditch effort for safety, not a pathway to services. We ask that you support this bill to further prevent the need for foster care in Kansas. In addition to workforce development, ongoing education and training for mandated reporters, which we're already doing a lot of, there will be an even greater demand to offer hard goods and services to families in need. Equity and Prevention is offering the $200 work boots at a $75 price until he can afford the work boots himself. We look forward to partnering with members of this committee in the future to ensure resources are available to support the successful implementation of HB 2132.
Thank you, Crystal. Next is Tanya Keys, Deputy Secretary, DCF. Welcome.
Thank you, Chair Howerton and members of the committee. It's a pleasure to be here today to support House Bill 2132. The purpose of this bill is really to have a positive impact on families. There's 5 pieces around that. We want to assure that poverty is not confused with neglect. We want to make sure that the need to enter foster care is tied to safety and harm. Children do not enter foster care for a reason of a truancy. They don't enter care solely to receive behavioral health or mental health services, and we want to make sure with this that families are going to experience an opportunity for services prior to removal. That's what we're hoping to accomplish with this bill. You heard from Jesse that within this bill there are 3 components of changes. The first change looks at changing the word failure to refusal in each component of the neglect, which is physical neglect, lack of supervision, and medical neglect. Those are the three components of neglect. Replacing the word refusal, it prioritizes family engagement and a deliberate agency assessment to make sure that we're not conflating poverty with neglect. The word refusal is an active tense, so we can assess how the family has been navigating resources when those resources are provided to them. The second piece is around the contents of the petition. And when there's a worry and the family needs to be separated from their family. So the new language requires a petition to demonstrate the facts that have a causal or include a causal relationship that would pose imminent harm for the child. So those facts in the petition need to demonstrate that causal relationship, and further, the facts need to address how that imminent harm outweighs the harm that could be experienced when they're removed into foster care. And in addition, as you heard, there are 9 conditions set forth that just by themselves would not be enough to demonstrate imminent harm, and that gets back to our goal that we don't want children to enter foster care for reason of truancy or mental health needs. And again, we also want families to experience an opportunity for a preventive service. So that third section that is a change in this is that the court would need to consider before a temporary order of custody whether prevention services might prevent the need for foster care, and inquire with that parent if there's an opportunity for that. Those are the 3 components of this bill. Briefly, background, we have had since about 2021 some conversations. You've heard from some other proponents who have been included in those conversations. Thriving Families, Child Welfare Reimagined, the Child Welfare Summit, and the System Oversight Committee have been talking about and looking at other states' definitions for a bit. And you heard from Natalie the states that in developing this bill that Kansas tried to match and find a good match for some of the language that we've chosen in this bill. With regard to fiscal impact, we don't anticipate a fiscal impact. There could be over time a projection of fewer reports or fewer children entering care, but for the purposes of this bill, we don't really project at this time any fiscal impact on this bill. We do have some related data, and I think Crystal also mentioned some of this data, but in our testimony we have data for the reports that DCF assigns for investigation of abuse or neglect. About 24% of the reports that our child protection specialists are going out on involve physical neglect, lack of supervision, or medical neglect. And that's almost 11,000 reports. And you can see that in the darkest navy blue on that pie chart. When we think about the definitions of neglect as it relates to the need to enter foster care, about 29% of children last year entered care related to a reason of neglect, such as physical neglect, lack of supervision, or medical neglect included in that. Thank you.
Thank you very much. Next up, we have Carrie Larnard, our Kansas Child Advocate. Welcome to committee.
Thank you, Chair. Ranking Minority Leader and Vice Chair. Apologize for going out of order. My name is Carrie Larnard, and I'm with the Office of Child Advocate. I stand before you in support of the intention behind HB 2132. I'm going to start out by saying that today we need to make sure that we're remaining child-centered and safety-centered. And we know that children being with families is best for children. And so I stand before you in support because it's important to know that one of the number one reasons that our office receives concerns is unnecessary removal. Oftentimes those are related to poverty and neglect. And there are very disparate decision-making that is happening across our state by our courts, by our DCF offices and our workers that are out in the field, as well as by our law enforcement officers. And so the intent behind this bill really is providing more clarification and guidance to those decision makers, so that we can make sure that we really are truly meeting families where they're at, providing the services that they need, and ensuring safety and the well-being of our children. I appreciate the fact that I'm towards the end of the proponent testimony, because I do think that this is an important conversation. And I stand before you because I don't think that HB 2132 is perfect. I think we need to have some good questions that are being asked, that we need to potentially make some changes to the language. But I do think that making some changes to these definitions is essential for our state in that direction. As we think about this definition, we also want to make sure that when we're thinking about leaving children at home, making sure that their needs are met, that we are also ensuring that there is that robust continuum of services that are available. I think that there's some important testimony that you're going to hear after me, providing some questions around that access to services, access to resources for our families. And I think that's essential that as a committee that you're hearing those concerns as we're weighing what that definition of neglect is going to look like, and what the standards are going to be weighed as far as removal. So one of the things I want to make sure and point out is that there has been some questions, I think, around the basis of what certain things cannot on their own be a reason for neglect and then lead to removal. And I think that what I wanted to point out in my testimony is that it's standalone. So if you take, for example, a parent who may have a cognitive delay, just the fact alone that they have a cognitive delay should not be the reason that we are removing that child from the home. However, there may be additional facts, circumstances, though, that in conjunction with that delay, that there may be reason for a need for additional services, support, and potentially then removal. But it's important that we're really identifying that those certain things on their own should not be just the reason. So I think Representative Burkamp had an example around substance use. And so again, it's the idea of how is that impacting the child and their safety. And so with that, Madam Chair, I know that you have a number of folks behind me, and I'd be happy to stand for questions.
Okay, thank you very much. Is there anyone wishing to testify orally for proponents? Okay, seeing none, I'm going to open it up to questions. Committee questions for the proponents. Okay, Representative Johnson, we'll start with you, and then we'll get Representative Page and then Burkamp.
Thank you, Madam Chair. Carrie, my question. I would like to know a couple of the examples on modifications to this bill, because I also agree that this isn't necessarily the perfect language, but the concept is so important. Can you give me now so I can start in on those?
Madam Chair, Representative, thank you for the question. Let me start out by saying I would encourage the committee, when you hear some of the opposition and review some of their testimony, there are some, I think, key suggestions in just the pieces of practice that we want to make sure that we're looking at how that language is being applied to avoid unintended consequences. One area that I think we should consider as you're reviewing the language would be that removal of the words likelihood of harm. Maybe we, consider leaving in the word likelihood of imminent harm, but we're still allowing there to be some discretion around the concerns around that occurring. Would be one area that I would encourage some discussion around. Representative, I also think I support the idea of the word refusal being substituted for failure, but I also understand that depending on how it's interpreted and defined, that there could be some concern with it being applied by the courts within practice. And I think that that's been brought up by our opponents as well. And so reviewing some of those other states that may have included refusal along with another word, or including refusal with failure in particular circumstances.
Those are excellent answers. Thank you.
Representative Page?
Thank you, Madam Chair. Ms. Carey, if you could. Thank you for your comments, and I appreciate your honesty because you said there are some things that we'll need to work on. And I find it hard to believe that when I hear people say no fiscal impact, some money is going to have to come from somewhere to help. If poverty is an issue, then how do we help them, and where are those funds going to come from to provide that assistance?
Madam Chair, Representative, and I think that's a valid point, and I'm not a fiscal expert, and so I don't know. I don't want to speak to the fiscal note that was a part of this House bill. What I will say is that if we have to consider what services we're providing to families prior to entering care, what are the needs that we're hearing, and what is available in their communities? We know that depending on where you're located at across our state, that services and our service array looks very different. And so as our families are coming to the attention of Department for Children and Families and law enforcement, and we're saying that we're going to leave a child in the home, but we need to know what those services are to make sure that that child is safe. And that's why I started out with, we want to start out with child-centered child safety. And so in response to the fiscal note, I also encourage, continuing to support those preventative services and really identifying the areas of our state where we need to amp those up.
Thank you.
Representative Burkamp?
Thank you, Madam Chair. This is for DCF. A lot of today's testimony seems to be focused around like poverty and not removing a child from home for poverty, which I agree with by and large. But I guess if a child, has been indicated that maybe they appear to be lacking food or some resources, do you guys do like a budget with the parents or guardian to say, how are you spending your money, and is it being spent appropriately, or like how does that process work on that front?
Thank you, Chair. Thank you, Representative, for the question. Yes, depending on the circumstances, the presenting situation, we can, in our engagement with the family, work through some tools to understand their budget, understand their needs, their expenses. We also can engage community resources, family resource centers, or other helpers to help them even a little bit longer to understand what their needs are, connect them to other resources that can help them, not just with the budget, but to understand what does that mean week to week and across 3 months. So yes, those types of services, supports are available alongside the family that a DCF employee might do, and also a service provider would do.
Real quick.
So then after you go through that, if they're still not able to take care of the child, that wouldn't be enough to remove them from the home basis. Is that correct? Just because the parent isn't failing to, they're not refusing, they just aren't able to because of like decisions that they're making.
We would want to look at the impact to the child based on that. Certainly, a need for concrete supports or services or augmented that's related to a stressor and an income. We also might be able to help get them additional supports if it's related to costs for food or costs for other expenses. So we would want to, once we understand their budget, perhaps help them and their network find resources to cover that. But really, we would, as that goes through and offering services and offering opportunities for support, we would need to know that there's a causal relationship between supports, resources, services have been offered, and there's a refusal to carry forward with actions that are needed, and the child has experienced harm.
Thank you.
Representative Humphries?
Thank you, Madam Chair. One question, sorry. Along those same lines, it's not, along those same lines and exactly what the other previous representative asked about resources. I'm curious, Gail and or Crystal, either one, they both mentioned, that there are resources available. And we talked about this before too with Family First or family preservation. There's an opportunity for more, but when people have to go through DCF to get a referral, sometimes they don't want to do that because they want to be completely out of the system. So I wonder if either Gail or Crystal could comment on that particularly, since I think you both mentioned it. And so which one of you? Okay.
Thank you, Gail, for stepping up.
Gail Kozad, thank you for the question. So as a provider of Family First services, and to be honest with you, so two things that I want to say about this. While we talk a lot about Families First funding, there are other sources of funding that are prevention services that come from DCF, that come from the Children's Cabinet and Trust Fund, that come from community partners like United Ways, county. So there are a lot of additional resources, and I think sometimes we forget that it doesn't all have to be funded by DCF, number one. Number two, for our Families First funded programs where a referral is required right now from DCF, we do have capacity to serve more families. And to your point, the challenge with that is around families, the way that they access those services, which is currently through an investigation of some sort, even if it's a family in need of assessment. Referral, and then a decision that there needs to be a referral, it has to come from DCF. We would be open, and I know Deputy Secretary Keys spoke a couple of meetings ago that said that, there's an opportunity to look at that, and I think that that's something that we would welcome as community partners. Yeah.
Thank you. Thank you, Madam Chair.
Representative Owsley?
Thank you, Madam Chair. And Representative Humphries might have taken part of my question. First, I want to say thank you to DCF for bringing us this and starting the conversation. I think it's an important one to have. And to Ms. Leonard's comments, I'd be curious maybe offline when we have more time to talk about the Child Death Review Board recommendations pointed out in your testimony. But then also, the different states, different definitions, some are refusal or failure. So, the likelihood of imminent harm, there are tweaks to be taken into consideration. And I appreciate the committee's treading lightly on this. I'd be curious, not only the 655 kids mentioned in, I think it was Crystal Hendricks' testimony, yeah. But if we could deliver services to a broader range, how many more kids could, stay at home with their families and reduce that trauma? And that's another thing too. I appreciate every conferee's recognition that removal is traumatic and needs to be weighed in the decision making. So to build upon Representative Humphries' question, Crystal, you said at the beginning of your testimony that your 18 agencies weren't always in agreement on this. And I would like to hear just if you have any comments on how you got here today, or if you'd like to expand upon how Family First services are delivered today versus how this could open the door for more services for more people.
Thank you for the question, Madam Chair, Representative Owsley. So 9 or so years ago, we made some shifts to how we serve juveniles in our state. And I think when we did that, there were some unintended consequences about how resources followed those kids in the new path in which we were serving them. And I think we maybe just have a little resounding trauma from that situation. And so just really wanting to make sure that as we reduce the number of kids in foster care, that we are making sure that resources are still staying with those families in communities, and just ensuring that families have the support that they need in that way. was the second half of your question.
Oh, just a pathway of getting services to more families. You know, and then the potential to reach even more so than the 655 that were removed for primary neglect reasons.
Sure. Gail spoke to it as well. There are prevention services that right now aren't meeting their total capacity. So I think it would be helpful to take a look at areas of our state where we continue to have high number of kids in care, and we could maybe run some pilot projects or something around. That's where we open up to some community referrals, where if someone steps into one of my members' buildings and says, I need help with X, Y, or Z, they can do that, and they can report that information back to DCF. And ensure that the federal government has the information that they need so that we can continue to pull in that funding. But specifically for DCF funds, I think there's some avenues there that we could dig into.
Thank you, Madam Chair. And in committee, when we were when the former chair and I were in DC for a child welfare conference with the Casey Family Foundation, DC specifically has a service provider that you don't have to have a case number for. You don't have to have a reference from anybody. Like you say, you just walk in, services are available, you need the services, you get the services. And if this has a potential to be something similar to that, the folks we met there were all extremely happy with the outcomes they were seeing there. So thank you, Madam Chair.
Any last questions for our proponents? Thank you. We're going to move on to opponent testimony. And I'd like to welcome to committee, let me reference first. There is several written proponent testimony. It's on the S drive. So if you'll look for them and be sure to read that as well. Okay, now opponents, I'd like to welcome Ed Klump to committee. The Kansas, he's with a lot of police and law enforcement. It's a list. I'll let you explain. Thank you.
Thank you. Thank you, Chair Howerton and committee members. It's a pleasure to be here to speak on this very important bill. My name is Ed Klump, and I am here representing, take a deep breath, the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. I want to start my testimony by saying that my comments are from the law enforcement perspective. And these cases of child welfare issues, I think there's different phases of these. You got, when we're involved, there's the law enforcement perspective, and then that moves on to DCF. We may take that child out of the home. Some of those children will never get into a foster care situation, probably because it's only temporary, that we need to find a solution. So I just want to keep that in mind. So I'm not speaking of how these things work for DCF or for the courts or for the prosecutors or anybody else, just law enforcement. We do not, law enforcement does not want to remove children from their home unless that is the only means we have to protect the child from harm or further harm. Removing the child from the home is a traumatic experience for everybody, the parents, caretakers, law enforcement, the child, everybody. It's a traumatic experience. And so I just want to make that clear. Our first concern in this bill is the removal of or preventing a likelihood of harm. When you remove that and the only thing left is harm, that means we cannot act in our position unless harm has already occurred. I don't think anybody wants to leave a child in an environment where harm is likely and then have to come back later after the child's harmed. We certainly don't want to do that. I don't think that's the intent, but that's a concern. As I looked at this, I thought that definition may work in the courts, but it doesn't work in our situation. So there may be a way to word that to make it work in the right phrase and the right thing. I'll also note that child in need of care is defined in the statutes, and it includes several forms of the word neglect. And again, if we use this definition, then the child is not already harmed. They can't be a sink, right? Because it's taken out of the definition. So just keep that in mind. And then finally, well, not finally, the next point, failure and refusal has come up. And if you look on the second page of my testimony under number 2, I looked up the definitions of those in Black's Law Dictionary, and I have them there for you because they're not defined in the statute. So I just have that there for your reference. And we do not think refusal works well in our situation. We do agree with the principle of financial situations shouldn't be a factor, but we are unable to determine that in our situation. When we're dealing with these on the scene, we have no way to evaluate that financial situation. Courts may be able to do that, DCF may be able to do that, but we can't in the environment we're in, and so that's going to be a problem for us. And I'll leave it there. I put a lot of other information in my testimony. I'll be glad to answer questions at the appropriate time.
Thank you very much. Next, I'd like to welcome to committee, he's on WebEx, Mark Jordan. Mark, are you there?
Yes.
Great, we can hear you. Thank you.
Okay. Yes, thank you, Chairman Howerton, members of the committee. I am the Chief Attorney in charge of the Child Native Care Division in the District Attorney's Office in Sedgwick County, Kansas. I've been a prosecutor in this office for 37 years. I've been involved in child welfare cases for approximately 20 years. I'm in court every day on these cases. I review these cases on a daily basis with DCF workers to make decisions as to whether or not it's safe to release a child that's been taken into police protective custody. I've got a lot of experience looking at these cases, and I can tell you on behalf of the Kansas County District Attorneys Association, who I'm speaking for this afternoon, we have some very grave concerns with the language in this particular bill. We do believe that it will place more children in harm. Obviously, we all want less children in foster care. We all want more services for children. I don't think anyone in child welfare disagrees with that. But if the only way we're accomplishing having less kids in foster care is by putting more children at risk, then we are not helping children. We are making the situation worse. I don't want to read through all of my testimony. You know, when I looked at this thing, I looked at Section 2 and I saw that list of factors that we can no longer consider. I thought to myself, well, that's like most of our cases. Unfortunately, the vast majority of kids that are in foster care are there because of substance abuse issues and mental health issues by their parents. And those issues standing alone oftentimes create very dangerous situations for children. And we don't want to have to leave those kids in those homes because now we've got something that's on a list of things we can't consider. And why would we want a list? I mean, if a decision's been made that a child is likely to be harmed if not removed from the home, that should be enough. We shouldn't have this separate list that we have to look at and say, oh, they're in danger, but it's one of these factors on this list, so there's nothing we can do. Our hands are tied. I think that creates a very dangerous situation. And so basically, if a prosecutor, a social worker, a DCF investigator, a judge says, wow, if we don't do something, we definitely think this kid's going to be harmed, our hands are tied if it's a reason that's on that particular list. We are also concerned with the change in the statute from refusal to failure. That really gets into an issue of criminal intent. I mean, that's something that can be litigated in a criminal case, whether the parent intended their actions. But what we're interested in child native care cases is the result that this has on the safety of the child. It's the child we're here to think about in these cases, not the parent's intentions. That's an issue for a criminal court. Certainly, if a parent, due to their being incapacitated, due to their use of, say, fentanyl, doesn't supervise their child adequately and that child is placed in a dangerous situation, certainly that child or that parent wasn't refusing to provide care, but he certainly failed to, and that child is in just as much danger. We think that is a dangerous path to go down. With regard to taking out the requirement of likelihood that a child is going to be injured and requiring actual bodily harm, I think the last gentleman that testified said it very well. We're here to prevent that tragedy from occurring. If it's likely that a child is going to be hurt, if a child wanders out in the street and fortunately that truck doesn't hit that kid, we don't have to come back a second time after the kid may not be that lucky the second time. And so we think if a parent, due to whatever reason, drug abuse, mental health issues, is failing to supervise their child, allowing the child to be in a situation where they could be seriously harmed or killed, we actually don't want to just have to say there has to be injury before we can do anything. So I really don't think this legislation, if enacted, does a lot to help kids. We all have the same goal. We want kids to be safe. We want them to be with their parents whenever possible. I don't think this bill is the right approach to doing that.
Thank you. I'm going to exercise a little chair privilege right here and ask a question just to clarify. You said that most of the children, most of your cases are due to neglect, and the bill states following, not to include any of the following alone. So do most of your cases only have one of those factors? Is that what you were saying?
It is, well, the majority of our cases have several factors. Most of the factors are, in fact, the ones listed on that list. I would say substance abuse issues and mental health issues with parents are the overwhelming reason why children come into custody. And sometimes it's both drug abuse or mental health. Sometimes it's just one of them. But if we have a parent that's using fentanyl, that may be the only factor, and it may not be safe to leave that child or children in that home. Fentanyl is so dangerous that law enforcement won't even touch it unless they're wearing gloves or special equipment. Why would we want to leave children in a home with a parent that's using fentanyl?
Okay, thank you. And Jesse, the revisor, just to clarify, the bill as written right now, it's following any of the following alone. So if there's two factors, could you just clarify that for me?
Sure. If there's two factors such as, let's take I, community or family poverty and isolation, that is allowed in a petition as facts to demonstrate imminent harm under the bill.
Okay, thank you. And thank you so much for your testifying, even on WebEx. We really appreciate that, Mark. Okay, next, and if you'll stand for questions, I don't know if you are able to do that, that would be amazing.
Yes.
Okay, and the next, Tabitha Owen from Kansas County and District Attorneys Association. She's on WebEx as well. Tabitha, are you there?
Yes, hi, can you see me?
Perfect. We can't see you yet, but we can hear you. Now we can see you.
Okay,
Thank you
great.
for being here.
Thank you. Good afternoon, Representative Howerton and members of the committee, and thank you for this opportunity to be here and testify. As you said, I am the president of the Kansas County and District Attorneys Association this year. I'm also the Smith County attorney in Smith County, Kansas. I have been the Smith County attorney for 12 years. And like Mr. Jordan, every year I've prosecuted these child in need of care cases, and that's because in rural counties, the county attorney does all of the cases. So I do the criminal cases and the civil cases, the child in need of care, the traffic, all of it. So I think that there's a unique perspective here, and I know that you all have my written testimony, so I don't want to just read that back to you. But I think that a couple of really important things that I wanted to point out is that, first of all, prosecutors across the state agree that poverty doesn't equal neglect, and that just being poor or struggling financially doesn't mean that you neglect your children. And I don't think that's a position that any prosecutor I've ever met has taken. And the law in Kansas already says that we can't take that position, right? The law already says that we can't base a petition solely on lack of financial resources. So really where the law is making the big change that we've heard a lot of discussion about is the change of the definition of neglect, taking out the ability to have any sort of preventative action is just really dangerous. If we say that it's only actual harm, we no longer have this likelihood of harm language, that's running a really risky situation. And then when you couple that with the refusal swap rather than failure, you really tie not only law enforcement's hands, DCF's hands, but also prosecutors in the courts, because now we're saying not only do you have to show actual harm to the child, but you also have to show that the parent refused services or refused to do something, some type of act that would have protected their child. So if I have a case with a parent who is abusing a substance, they're so intoxicated that they're passed out with a young child or a baby in the home, that's an incredibly dangerous situation. But if the baby's not harmed yet, then we're saying, I guess we'll wait and we'll come back later and see if this mom wakes up or this dad wakes up or this caregiver sobers up. That just seems counterintuitive to me. And I imagine that's not what anyone in this room wants, and certainly not what people who work in social work actually would want. But I do think that that's the result of this language change. And then secondly, there's another issue where we talked about in the temporary custody hearing, that language there, where in effect using shall, that the court, if the parents, let me just back up. So in a temporary custody hearing, right, we have to have one of those within 72 hours because those happen in cases, we use them in cases where the child is in danger, where the child does have a significant risk of harm. It doesn't mean that the child actually has to have been harmed, but has a significant risk of harm. And so the court can't remove a child at the temporary custody hearing without finding probable cause that the child's health or welfare may be endangered without further care. But the change in this bill would make not only the court has to make that probable cause finding, but now they also have to allow the parent to agree to participate in services. And if the parent says, okay, now that you're threatening to remove my children, then I will participate in those services and I will go ahead and accept something, then the court shall return those children. So that really takes discretion away from the courts.
Okay. Does that wrap your testimony up? Okay, there she goes.
Yeah, sorry. I could see that you were talking, but I couldn't hear you. And so I wondered if I'd just been talking the whole time and you couldn't hear me.
Nope, we can hear you. You're good.
Okay, I had like a panic. Like, have I just been a moving head on the screen? Okay, so I will wrap up though. What I can tell you is that the idea of offering the services in the courtroom isn't something new. This is something that we see all the time. I don't know I can't testify as to what services exist in the metro areas, but I can tell you that in rural Kansas, the services that a family needs when there is serious mental health crisis, when there is serious drug and alcohol abuse that puts these children at risk, the services that those families need are intense. They need mental health treatment. They need drug and alcohol treatment. They need a lot of social work in the home if you want to keep the children in the home safely. And those don't exist in rural Kansas, not practically speaking. There is not. For example, I have a case right now. We just returned a teenager, home with her father on a family preservation referral. There's some sort of issue. The way it works here, you get your referral through DCF. Their contractor where I live in Smith County is TFI. They make the referral. That person's supposed to come to the home. I can tell you, I just spoke with the social worker. The referral was made on January 23rd. There was an error in the referral that has the wrong name, like the grandmother's name instead of the father's name. And that family still, January 23rd, does not have an actual referral. They keep trying to get the name changed. They can't. I mean, it's ridiculous. So, and this is not uncommon. I get referrals for family preservation, and they live so far away, these workers. It's not a worker problem. Just let me be clear. I'm not talking negatively about an individual. Everyone that I work with, they're wonderful people. They care about families, right? But they maybe have to drive 2 hours to come to our community to be in this person's home. They come once a month, twice a month, something like that. That's not really enough to ensure the safety of a child when you know that their parents have a serious substance abuse issue. Like Mr. Jordan said, if we're talking about methamphetamine, fentanyl, serious drugs, those kids are a serious risk and it needs a serious response. And so this bill really strips us of our ability to protect those at-risk children, and it doesn't add any additional service to them. The fiscal note says this doesn't cost anything. So where's the service? How do we fill this enormous gap that will be left if this bill is passed the way it's written now? I don't know how those kids get the services they need or those families get those services.
Okay, thank you very much, Tabitha. A little over time, but we're going to go with Morgan Hall. Welcome to committee. And if you can stand for questions, Tabitha, that would be great. We may have questions for you. Thank you.
Good afternoon, Chairperson Howerton and the committee, and thank you guys so much for allowing me to be here today. Okay. As everyone else has said, I don't intend to kind of regurgitate my written testimony. You have that in front of you. I come to you as somebody who has chosen to dedicate her career and her life to children, whether it's through the child welfare system, whether it was serving on my local school board, whether it is being married to a teacher. I grew up with an aunt who was a foster parent, and that's what developed my love for this particular area of the law. While there are a lot of concerns, and I want to first say that I do appreciate Ms. Lawnard pointing out that although she is a proponent for this particular bill, that there are issues that remain in that, and you'll see that through my written testimony. But I would concur that obviously we don't want to remove a child simply because of poverty reasons. As a prosecutor, trying to make the decision to recommend removal of a child is one of the most agonizing decisions that I've ever made. It's not something that I take lightly. It's not something that I think any of us would take lightly because we know that there is trauma surrounding that. But at the same time, we have to ensure that a child is protected. I want to go through some of the questions that you guys have had and just hit on some of the things that sort of stuck out to me in particular. I know there's been quite a bit of questioning surrounding whether it is a singular incident or instance that is outlined that is the request for removal. One of the other things that I've had the great opportunity to do as a prosecutor in Shawnee County is handle our mental illness cases, so the involuntary commitments due to mental illness. In doing that, it's helped me to better see that you may not see that there is a coinciding incident, so they may be suffering from mental illness, or more likely, you see that there's a drug addiction and you don't know that there's that coinciding mental illness, but that is then what is adding the additional layer of concern in addition to simply the drug use, but you don't know that until you've been working with a family and involved with a family. I appreciate that we do have Family First Prevention Services and that Kansas was quick to act on that particular area. But the realities in the day-to-day, and while we are fortunate that I do get to live in a larger community and get to practice in an area where we have a fair amount of resources, the reality of the practice of that is there is still a huge lag time in getting those services and resources to families. The number of times that we're told, I'm sorry, but we have a 1-month wait list before you can get to that, or we have to have a court order before we can allow you to have access to those services. So the same system that is overburdened currently by children in foster care is the same system that is overburdened by trying to keep families at home. We do not have enough workers. We do not have enough people that are willing to work in this area of the law. I appreciate that there has been so much focus on child welfare, especially recently. I love that we did the summit that we did, and there have been ongoing conversations, and that you guys are taking a look at this and really diving into it. And I think helps to start the conversations to say, how can we fix this? How can we work to remedy this? But it's the people that are the boots on the ground that are dealing with this day to day that are best equipped to make those recommendations. I also have had the benefit of getting to speak with prosecutors or agency attorneys, I should say, because every state handles things differently from across the entirety of the country. And I think one of the benefits and one of the things that we have in Kansas is that we're independent of the agency. We do not work for DCF. It is our prosecutorial discretion as to what our recommendation is going to be to the court. But even in that, it's not our job to remove a child. It is simply our job to go in there and say, hey, here's everything that's going on, here's all the information that we have, and let the court make the most informed decision that they can. And I think they're more equipped and better equipped to do that than having a mandate that a refusal is what is required in order to potentially look at removal of a child. The children that I referenced in my testimony, in my written testimony, those are cases that I've had. Those are things that I have seen. And those are just a very small drop in the bucket of what I see every single day and have seen every single day, both as a prosecutor and back when I represented the children and got to have the opportunity to have those conversations with them. So I appreciate that you guys are taking the time to look at this, but I would ask that you rework this bill. I do not believe that it is functional or feasible for families or for children as it is currently written. Thank you.
Thank you. And then the last opponent I have is Mike ks. I probably butchered that name. Sorry. You may correct me when you get to the mic.
Madam Chair, thank you. You did not butcher the name. You're one of the few that gets it right. So thank you. Madam Chair and members of the committee, my name is Mike ks. I am the district attorney here in Shawnee County, and I am here to offer my strong opposition to this bill as it is currently written. I have a couple things I want to say off the top, and then I want to run you through why I think this is a problem. First of all, there are well-documented problems with the foster care system. We all know it. This is not an either-or equation. This is not, let's reduce the number of kids going into foster care because the foster care system is flawed or broken. We can do both, right? We can give support to parents. We can improve the foster care system, and we can still maintain the ability of law enforcement to protect vulnerable kids. And that's where I want to begin. This bill has language in it talking about, well, it removes the likelihood of harm, and it replaces that with acts and omissions that result in the harm, okay? And someone had the foresight to commission a study on the neglect definition on all the different states. I was reading through it, just sitting here while I was listening to the proponent testimony. I cannot find a single state with similar language. And I am happy to be corrected, but I did not see it in my review. I think this goes too far. I think it removes our ability to act when needed. As far as the poverty provision, there is a title on the bill, and it specifically cites prohibiting the removal of a child from such child's home due solely to a lack of financial resources. And Tabitha already testified to this effect, but I wanted to cite the specific statute for you. I did bring it with me. KSA 38-2202, subsection D1. And this is under the definition of a child in need of care. So D1 says, this is without adequate parental care, control, or subsistence, and the condition is not due solely to the lack of financial means of the child's parents or other custodian. You've heard prosecutors say we don't use poverty as a reason. We can't. The law does not allow it. So the premise of this bill, if it's let's protect poor families that can't take care of their kids, okay, I'm with you. Let's do it. Let's give them some more support. But if it's let's stop prosecutors from taking poor kids out of poor families, that does not happen. That's not why we file these petitions. That's not why we act. I want to direct your attention to a case that happened here in Shawnee County, in Topeka. This is the case of Zoe Felix. I don't know if you've heard about this before, but Zoe was a 5-year-old girl, sweet, kind, funny, innocent, and without adequate parental supervision. She was brutally assaulted and murdered here in Topeka after being left in an unsafe environment. one that DCF had been warned about multiple times. There were 9 reports. 9. Most of them were investigated. None of them made their way to my office. Not a single one. This case is not a failure of excessive removals, it is a failure of inaction. HB 2132 makes intervention even harder, setting up more legal roadblocks that will allow future children in dangerous homes to suffer the same fate. HB 2132 modifies the legal definition of neglect by replacing failure with refusal, fundamentally altering how cases of neglect are assessed. This shift is not just a technical change. It makes it significantly harder to intervene in neglect cases where children are being harmed. Proponents have argued that this change ensures parents are not punished for poverty, but in reality, this is creating a legal loophole that allows neglect to continue unchecked. A parent suffering from substance abuse to a hard drug, severe, chronic, and untreated mental illness, or domestic violence may not actively refuse the assistance, but that does not mean that their child is safe in that environment. This bill shifts child protection law away from focusing on whether or not a child's basic needs are met, and instead forces agencies to prove intent, an unnecessary and harmful legal barrier that will keep children in dangerous homes. Instead of restricting removals, Kansas should focus on strengthening oversight of child welfare agencies, improving coordination with law enforcement, and ensuring that cases like Zoe's don't happen again. For these reasons, I am strongly urging the committee to reject HB 2132 in its current form and pursue reforms that strengthen rather than weaken the state's ability to protect vulnerable children. Zoe Felix deserved better. Kansas children deserve better. Thank you for your time.
Thank you very much. There are 2 written-only opponent testimony. One was just uploaded during committee. It got in late from Rick Macias from Sedgwick County. It is on the S drive and on the website as well. Opponents. Yes, ma'am. Okay, questions for opponents? Oh, wow. Okay. Should not have looked down. I don't know who was first. Representative Neighbor, we'll start with you.
Thank you, Madam Chair. Chief Clump, can I ask you a question? I only have one because I was told one.
Thank you.
Honoring.
Yes.
During the making of this bill, were you invited to the table to have input?
We were not.
Thank you.
Did you participate in the Child Welfare Reimagined?
I did.
We discussed this a lot.
Well, the bill was discussed,
Okay.
yeah.
Okay.
But the details of the bill were not really discussed in any of the meetings I was at anyway.
Okay, perfect. Thank you.
Yeah.
Thank you.
I did participate in that, yeah.
And we appreciate that, yes. Thank you. I just wanted to clarify. I knew you were on there, but I didn't know how deep because I didn't make all the meetings. Okay.
But we weren't involved anything directly with the development of the bill.
Correct. Okay.
Right.
Thank you. Representative Barth?
Thank you, Madam Chair. My question is also for Mr. Klump. After reading the bill and hearing all the testimony, I actually see this bill as almost being it needed a 2-step approach. It's a singular approach, kind of a one-size-fits-all, and it seems like we missed a little bit of the moment when there is an issue and a child is potentially at harm or in harm in a home where there's something happening. I just was visualizing, a man trying to hurt the woman, and yet the child wasn't hurt. But it was a rough situation going on and dangerous in that moment, but yet the kid had not been harmed. And so I'm just wondering, is DCF there with you alongside you? Because I don't really know how the process works. Can you kind
Rarely.
of give me a little bit of idea of what that looks like? Thanks.
Rarely are we there together. Sometimes DCF asks us to go along when they're investigating something. You have to keep in mind, DCF operates 8 to 5, Monday through Friday generally. Now, we have areas of the state where we have a real good working relationship with the local DCF staff, and we can actually pick up the phone, call them on a cell phone at 8 o'clock at night and get an answer. But that's an exception, not the rule. We recently did a survey. I did 2 surveys, one of street officers and then one of investigators of child welfare. And 80% of both groups said they really desperately would like to have the ability 24/7 pick up the phone and talk to a caseworker about the conditions they're seeing and get advice. And that is not available.
And we are going to invite Mr. Klump back after turnaround to have a whole hearing on this issue. So, yeah. Do you have those surveys available now?
I do.
Okay, if you wanted to share them with our committee assistant, I'm sure we would like to get a head start on that.
I will send them to you or to the committee assistant, and you can share them as you see fit.
Thank you.
I have discussed them with DCF, so they're aware of them.
Thank you. Representative Page?
Madam Chairperson, can I ask Ms. Hall a question if she would come back up? First, I want to say thank you for what you said, your honesty, and how we struggle. Because when I've asked some people before about the fiscal impact, people kind of fudge on that. Because we want to help, but sometimes it takes money. And in this age and day, it seems to be we want to cut, and I get that. But at the same time, you can't do both. Can't have your ice cream and cookies both. But can you give some numbers in terms of how many people, young people, may have been killed? The gentleman gave one example, and I know I live in the metropolitan area, Kansas City, Kansas, KC We had 2 major cases. One, the lady was on drugs, cut her baby's head off. The second case, the parents killed the child and fed it to animals. So I don't know if you have any other numbers that you all keep track. And
I don't have numbers. I can tell you the 2-year-old that I was talking about was, she died from starvation. The older brother did not, and father had substance abuse issues. There was a criminal case that then eventually arose out of that as well. But she had remained in the home throughout the duration.
do one follow-up real quick.
Real quick.
Do you have data on substance abuse? And do we have a program that if a parent had a program, they could get some help if they're struggling with this?
And DCF could better give you the information on that. I know that there are resources, and I know that there has been an improvement in those resources and availability, as there are treatment facilities that will now allow a parent to come and with a child. I think part of the difficulty that we don't necessarily consider is you can lead a horse to water, but you can't force them to drink, and the number of times that they're willing to accept those services, but the follow-through does not occur. But I do not have the numbers off the hand.
Thank you, ma'am.
Representative Esau?
Thank you, Madam Chair, and I'll make it really short. Ed Klump said something, you don't need to comment, it brought something to mind that I'm also hearing concerns about DCF not being available 24/7, and when there are reports of cases of new moms with drug addiction, and the nurses are left with, that they can't do anything unless they call the police. So I think sometimes we're dumping too much in the laps of our law enforcement, and we've got to find a solution to it. So I'm glad that you're going to have him back so that we can have that discussion in more depth. Thank you.
Any further questions? Okay, I have one question, and I don't know if this is for DCF or possibly Ed Klump, but do we have a number on how many children are taken into that 72-hour police protective custody and then at the temporary custody hearing are sent home? Does anybody have an idea on that?
Thank you, Chair, for the question. I would have data that would be the inverse of that. So I do not have the data that you request, but we do have data on the number of children who enter a temporary order of custody who had had police protective custody prior.
Do you have a total number of children that were taken into police protective custody?
Yes.
Versus, so you could get that number. So if you have the total number and you have the ones that were sent into foster care, sorry, then we could subtract that and get the difference, correct?
Yes, I can look to see if we have the total in that sense. Yeah. Yes, I could look to see that, yes.
I would be interested in that. Thank you. And Mr. Klum, did you want to say something? Thank you.
And I do not have numbers. I just want to caution you that numbers are misleading on this topic because there's a whole, I can give you a whole discussion, I'll do that when I come back, about why police protected custody numbers are high.
Okay, that would be great. We'll look at that in the future then. I look forward to that discussion. Anything else, any other questions for the opponents? Okay, committee. So this is a very important bill, I think, and I'm just going to state the obvious. If you saw that there is a definite divide between opponents and proponents, proponents were child welfare workers, stakeholders, opponents were law enforcement, courts, and district attorneys, which I find very interesting. I'm going to dig a little bit more into that because I am curious why we are divided. That may be a systemic issue that we need to look more into. We will open this up for discussion on the committee, possibly working this bill next Wednesday. I want to give you a week to talk to our proponents and opponents, and feel free to reach out to them. I'm sure they would love to have a conversation with you, and vice versa, opponents and proponents. Please talk to us if there's something we can do or we need to seriously consider for amendments. We will be discussing this bill and possibly working it next Wednesday. So the divide is very interesting, needs to be heavily considered. Changing the definition of neglect will change the direction of our child welfare in our state. And so I'm depending on you to do your homework, to read the testimonies, dig through this, look at the state, and come up with what is right for Kansas. That is our job. That's what we've been tasked to do. And this one is a heavy lift, and it's a big lift. And maybe we do something, maybe we don't. But we need to just consider that. So I appreciate everyone for coming forward today. Both sides, I was really hoping for a healthy discussion with all perspectives, and I think we definitely got that. And I do appreciate any other business for the committee. We'll postpone the minutes.
No, are we supposed to meet Friday?
Yes, that's what I was going to say. We are meeting on Friday. Don't forget, we are meeting on Friday. If you cannot be here, I need to know as soon as possible. We are going to be hearing HB 2175. So hearing on HB 2175 on Friday at 1:30 in this committee room. Okay, thank you. You are adjourned.